Hello, everyone. Welcome to our webinar today. We're going to get started in about 2 minutes. So just sit back, relax, have another cup of coffee, and we'll be with you in just a moment. Thank you. Okay, I think everybody's coming in today. Hello, everyone. My name is Michael Ibrahim. I'm program manager with the Cultural Investment Portfolio at the Mass Cultural Council. The Cultural Investment Portfolio's focus is grants and services for nonprofit cultural organizations, and we are excited to deliver today's workshop to you today, the Nonprofit Employment Law Basics. This workshop is part of our Recover, Rebuild, and Renew efforts to help organizations come back from COVID-19. This spring, we are offering 2 free workshops every week, every Tuesday and Thursday, in the areas of financial management, legal issues, what we're here to talk about today, human resources, advocacy, management, and governance. Feel free while you have a moment in the chat to introduce your name, your organization, and title if you'd like to share. Joining us today are Luke Blackadar from the Arts and Business Council of Greater Boston, along with Danielle Letterman, an associate from Morgan, Brown, and Joy LLP. They are going to introduce themselves in just a moment, but a few ground rules before we get going. As you can probably tell already, this session has automatic captioning. These are provided on all Mass Cultural Council Zoom meetings and webinars. If you need additional accommodations to ensure your participation for future webinars, just let us know when you register. If this is distracting for you, you can hide this by clicking hide subtitles in the closed captioning option on the bottom of Zoom. We will have time for questions and answers throughout the presentation. We ask that you please use the Q&A function and not the chat to ask questions. That way we can organize all the questions better for our guests. And that will help keep things organized. And this session is being recorded and will be available on the Council's YouTube channel afterwards. You will get an email from me since you've registered for this session when that recording is available. My colleague Carmen Plazas is here. She is providing some resources in the chat box as we go along, including the presentation from today. Additional materials that Luke and Danielle want to share, including that presentation, will be emailed afterwards. This session is scheduled for 90 minutes, including the time for questions and answers. And with that, I will turn it over to Luke and Danielle.
Great. Thank you, Michael. Hi, everyone. My name is Luke Blackadar. I'm the director of the Volunteer Lawyers for the Arts of Massachusetts. And this is part of our mini legal series within the Renew, Recover, Rebuild series through Mass Cultural Council. So today we're going to talk about fundamentals, basics, introductory material about employment law. And I'm joined by a friend of mine and classmate from law school, Danielle Letterman. And I'll let you introduce yourself.
Thanks, Luke, and thanks to the Mass Cultural Council and the Arts and Business Council of Greater Boston for having me here today. My name is Danielle Letterman. I'm an attorney at the law firm of Morgan, Brown, and Joy. I've been practicing law for just over 8 years. I practice employment and labor law on the management side. So that means I counsel and represent employers in all aspects of their business, including everything from discrimination, sexual harassment, counseling relating to employee handbooks and contracts, to wage and hour law and retaliation. I previously worked on the employee side as well, so I've really dealt with these issues from all angles. That being said, let's talk about employment law, my favorite topic. So I wanted to start with this agenda to give everyone a sense of what we're planning to cover today. It is a lot. We'll also be having another session in May concerning issues around work from home, which is likely to stay pretty relevant in the present pandemic, and given how businesses are changing the way they operate. So stay tuned for that as well. So the goals for this session are to give an understanding of the legal framework of employment law in order to avoid risks and pitfalls which face every business at one time or another. We're going to go through some common employer mistakes as well as to how to avoid them using some specific examples. So through this agenda, we'll start by defining what employment law is, defining what employees are and how that can vary, and then we'll go right from the hiring process all the way through to issues surrounding termination. So we'll start by defining what is employment law. Employment law is a field of law that governs the relationship between employers and employees. That definition can sound a little misleading because employment law is not necessarily limited to just employees. There are aspects that can apply more broadly, not just to employees, but also to volunteers, independent contractors, and third parties. In general, most people who work are considered to be employees, therefore they have to be at minimum wage, be paid at minimum wage or higher for all the time that they work. However, volunteers and some interns may work without pay. There are specific standards that must be met in order to determine whether someone qualifies as a volunteer that doesn't need to be paid. Under federal law, those standards are set out by the Department of Labor. In Massachusetts, those standards are set out by the Massachusetts Department of Labor Standards. The definition of an employee under federal law is still pretty broad. It's anyone that the company suffers or permits to work. Under Massachusetts law, as we're going to discuss shortly, that definition is even broader. So today's presentation is generally going to focus on employees, but employers should keep in mind that some of the laws might apply more broadly than that to volunteers, independent contractors, as well as third parties. So for our first topic, we're going to talk about exactly what some of these words I'm throwing around mean. Specifically, I wanted to start with breaking down the concept of what an employee is versus an independent contractor. In Massachusetts, there's a legal presumption that if someone works for you, they're your employee. That's the default in this state. So in order to employ an individual as an independent contractor instead of an employee, a business needs to prove three things: that the individual is free from control, that the individual performs a service which is outside the employer's usual course of business, and that the individual is customarily engaged in an independent trade, occupation, or business. If a business can't show all three of those things, then that individual in Massachusetts is going to legally be viewed as an employee rather than an independent contractor. The specific law that sets out this three-part test is known as the Massachusetts Independent Contractor Statute, and that's located at Massachusetts General Laws, Chapter 149, Section 148B. So why is it important that your business gets this classification right? And it's because an employee, when someone is employed as an employee, they're entitled to certain rights that independent contractors are not entitled to. That can include the right to minimum wage, overtime, workers' compensation coverage, leaves of absence, and accommodations, a lot of which we'll be discussing later today. So if you get the classification wrong between an employee and an independent contractor, as a business, you could end up being on the hook for everything that that individual missed out on by being misclassified as an independent contractor. the crucial element of this three-part test tends to turn on the first part, that freedom of control prong of the test. It's a very fact-specific inquiry. So when this issue comes up in court, and it does come up a lot, courts are really looking at this in the specific context for your business. So what are the facts that a court's going to be looking at to determine whether an individual is free from a company's control? Well, that can be a wide range of things. They'll be looking at who has control over the hours the individual is working, who's controlling the terms and conditions of that individual's work, who between the employer and the individual is providing the tools to do the work and furnishing the materials necessary for the work, whether that person is holding themselves out individually as doing work separately from just this one employer by offering services that are available to the public, whether or not the individual has a continuing relationship with this specific employer versus a short-term set project. There's a lot of different factors that courts will look at in terms of deciding whether someone's an employee or an independent contractor. So it's this very fact-specific inquiry. In Massachusetts, it is really difficult in practice to meet all three of those prongs that make someone an independent contractor. So that's where this presumption of employment comes from. Most individuals who work for a business are going to be defined as employees by default.
Yeah.
Sorry, go ahead, Luke.
I would just add that it is important to understand this distinction because it's a question that I'm sure you get, Danielle, and that I get a lot at the Volunteer Lawyers for the Arts of, can I switch my employee from 1099 to W-2 back and forth? And it's really important to get that this is not really within your discretion to decide what the classification is. It is, like Danielle said, it's very fact specific. It depends on the actual circumstances you're dealing with. And we totally get that there are going to be times and disciplines where you prefer and your workers prefer to be classified as independent contractors, for intellectual property purposes, which is a whole own discipline. But I think, that's just a point that's important to emphasize, is that you don't really get to choose how your workers are classified. It really does depend on, the law and the facts you're dealing with.
Absolutely. You're absolutely right, Luke. It's very true in that it's a very fact-based situation. And in Massachusetts, it's very hard to get around no matter what you as a business or even the individual may want to do. Mm-hmm. Some of the consequences that can arise for a business if they misclassify an individual as an independent contractor when under Massachusetts law that individual should have been classified as an employee can include back pay, overtime pay, employee benefits like stock options, retirement benefits, healthcare plan coverage, all of those things that you weren't entitled to as an independent contractor, but would have gotten if the classification had been made correctly as an employee. So determining whether someone's an employee and how to classify them can be complicated because the answer turns on the specific facts of each and every case, and can also turn on which laws are relevant to the analysis. And to Luke's point, sometimes it's helpful to run through examples. So here's an example where you hire a new trainer, Bo, to work in your fitness center. He wants to be an independent contractor, not an employee. So you're trying hard to remember if that employment lawyer said anything on this topic at the last MCC program you attended, and you recall there might be an issue with this. So you're expressing some reluctance in response to Bo's request. Bo says he'll sign an agreement where he acknowledges that he's an independent contractor. Well, that seems great, right? Or does it? Luke, if you're up for it, we can run through a little role play here.
Sure.
So the setting is manager processing the hiring paperwork for Bo. I'll play the manager and Luke can play Bo, so we'll get started. Happy to have you on board, Bo. Please fill out this W-4 so we can get you set up in the payroll system.
Oh, yeah, I forgot to mention, I want to be paid 1099 as an independent contractor. I'm going through a divorce and kind of want to keep things simple and on the down low.
Well, I'm not sure that's okay, actually.
Oh, well, if you're worried or concerned about it, I'm happy to sign an agreement. Happy to acknowledge that, I'm an independent contractor. We have no employer-employee relationship. I've done that for a lot of employees before. It's pretty common in this industry.
Oh, well, okay. I guess if you're willing to sign something that says that's what you want, then that should be fine. I'll draft something up and you can sign that. So, end scene. That's a situation that can come up very easily especially in a smaller business setting. And the answer you want to provide in that situation is much more something along the lines of, look, Bo, I understand that's what you want, but the business really won't allow that. You're an employee, it's a legal decision, not yours, not mine. And that means you have to be paid by W-2. So can you fill out the W-4 form now? In practice, employees are paid via W-2 and independent contractors are paid via 1099. But it's really important for employers to know that how you choose to pay someone does not determine that fact-specific analysis that we were going through about whether or not that individual is really an employee or an independent contractor. In Massachusetts, the presumption is that an individual hired for work is an employee unless you can prove otherwise by proving all three prongs of that test. Even signing a written agreement where someone says they're an independent contractor will not get you off the hook for that.
And we do have a related question, Danielle.
Sure.
So does the number of hours worked have any bearing on employment status? For example, if they're 1 to 10 hours a month?
So like we said, it's hard to say because it's a very fact-specific analysis. So if that fact, along with all of the other facts, points towards employee versus independent contractor, that could be relevant. But because it's a very fact-specific inquiry, it's not reliant solely on the hours. So you're not going to make the decision based upon somebody working 3 hours versus somebody working 60 hours a week. Luke, do you have anything you wanted to add to that?
No, I mean, it's fact specific. And I think, like Danielle said earlier, it tends to fall, and this falls, similarly with, when we're doing this analysis for intellectual property, it really does relate to the conditions and the manner in which you're working, and really how much control does the employer exercise. And it's going to vary a little bit from state to state. Like Massachusetts, as Danielle said, we presume an employer relationship because we're very, our state is very employee friendly. We want to extend more benefits. We want to extend more protections to employees. So you also have to consider the policy reasons behind it, if that helps kind of help with your understanding and assessing what your relationship is. You think, is this the type of work that the state would probably think I have the obligation to protect my employee versus, a very traditional example, like having an electrician or a plumber, where it's like they work their own hours, they work their own materials, they provide their own resources, et cetera. So it's a number of factors, but a lot of the factors that are usually going to be most telling are those ones that indicate what is the extent of the employer's control.
Absolutely, completely agree. Couldn't have said it better. So now moving on, now that we've discussed the employee versus independent contractor issue, we want to talk about employment at will. So most employees are at will. This assumes that there's no written contract that's specifying the exact length of an employment relationship, and therefore the employer or employee can end the employment relationship whenever one or the other chooses. However, at will does not mean employees can be terminated for illegal reasons such as discrimination or retaliation. There's a number of exceptions to at will employment. For instance, when employees have a contract for a certain length of time, sometimes a 1 year or 2 year appointment, the presumption is that employee is going to be employed for that period of time, though it can depend on the terms within that individual's contract. And the terms themselves might require that the employee cannot be terminated without cause or for any reason at all. So that would be an exception to the at-will doctrine. Also, unionized employees don't fall within the at-will employment doctrine. Also, employees sometimes claim, public policy claims or a breach of the covenant of good faith and fair dealing, which is implied into every contract. So there are exceptions to the at-will employment doctrine. Essentially, you can't terminate someone for an illegal reason. So whether that's discrimination, retaliation, If you're terminating someone because they exercised a legal right, like filing a workers' compensation claim, or for performing a legal duty, for example, serving on a jury, you can't terminate someone for engaging in what's called protected conduct or protected activity, which we'll cover in a little more detail later today. But even all these exceptions, at will employment, there are a lot of latitude to terminate an employee whether or not there's real reason for that termination. In practice, I would caution employers that if an employee raises a legal claim in response to their termination, an employer might end up needing to show that termination for a legitimate reason, even with the at will employment doctrine. So we'll discuss termination in a little further detail later on. Anyone have any questions relating to employment at will?
Hey, Danielle, I do have a question that I'll pose to both you and Luke, if you don't mind.
Sure.
Someone says, say you hire someone to work for you from another state. Does the definition of employee versus contractor in Massachusetts govern that relationship, or is it the law in the state where the worker lives?
That is a great question, and unfortunately a very complicated answer. It can depend a lot on the state. For businesses, usually my first recommendation is talking to your payroll company. Sometimes they can help you figure out the classifications on a state-by-state basis. Sometimes it can depend on what the laws in each of the individual states say. So there can be, depending on the law and how it's been interpreted, that answer can unfortunately vary quite a lot. It's very good to be thinking about, and it's definitely something you want to be consulting with your payroll company and your counsel about, because it can depend a lot on the specific law involved. An employee might be classified as an employee from one state under a certain law and a different state under other laws. So it's definitely something to be aware of.
Wonderful. And one last question before we can go on.
Sure.
Does any of this change when you're an arts organization hiring an independent artist for a short-term project?
And I think that's related to the independent contractor question.
Yes, but and the answer is rather similar to what Luke and I were discussing before. It's a very fact-specific inquiry in terms of determining whether or not the individual is an employee or an independent contractor. So it can vary depending on the nature of your business, depending on how prevalent what that individual is bringing to your business, if that's very much in the same line of service that you're working within or not.
Great, thank you.
No problem, thanks. Okay, now we're going to talk a little about the hiring process. Hiring can be one of the most potentially problematic areas in employment law. So employers need to really be careful about making promises regarding the terms of employment, conditions, length of employment that they're promising to applicants, especially if it's promises that they can't keep, because you might be held to those promises under the law. So an employer's goal in hiring should be to select the best candidate possible, comply with the law, and maintain that right to terminate an employee at will unless it falls within one of the contract exceptions we talked about earlier. So this slide shows some tips and best practices to keep in mind for hiring. You want to start by trying to control the application process as much as possible. For instance, have a job description ready before you advertise for the position. Review and regularly update your job descriptions to ensure that what it says is actually describing what that person does in their position. Be aware of what you can and cannot ask in an interview. Create some guidance so that your team who's doing the hiring is consistent and lawful in the interviews that they're giving. Consider the need for pre-employment background checks and ensure your process for such background checks is compliant with the various laws that govern that. Try to be cautious and calculated when you're asking interview questions, and try to aim those questions at the specific skills needed for the job. You want your questions to really focus on what the essential functions of the job are, and you want to ask the candidates for examples of how they have or would handle certain scenarios that illustrate the need for the skills you need in that position. Don't forget to look within your own organization for applicants. Try and keep each interview as consistent as possible. That can be difficult, but it's good to try. Check references when they're given, and make hiring a team effort. Really, get your hiring team together, and so that everyone's on board and looking for the same qualities for their open position. Try to consider implementing whether you want to impose an evaluation or probationary period for someone when they start, and always document. You're going to hear me say that a lot throughout this presentation. Documentation is very important, but try to document your reasons for selecting candidates both during and after the interview, and you want those to be objective reasons as well. So that's something that you'll be reviewing. Both federal and state law can require and prohibit certain questions during the hiring process. So that's why we're going to cover this today and try to make sure you're familiar with as much of them as possible. So in order to know what you can and can't ask about in an interview, we're going to start by going over what's called the protected categories. Those are characteristics that are legally protected in Massachusetts. In the hiring context, this means characteristics that you cannot use to make your hiring decision. More broadly, these are categories that are protected from employment discrimination and retaliation in hiring, firing, and everything in between. So you want to make sure you know the protected categories under federal law, under the states you're operating in. This list right here is showing the protected categories under Massachusetts law. It is broader than federal law, but it can vary state by state. So this list includes race, color, gender, pregnancy and pregnancy-related conditions, gender identity or expression, sexual orientation, national origin, ancestry, religion, age actually over 40 is the protected category. You're not protected based on age when you're 35. So that's another thing to keep in mind. Some of these can be limited. Military or veteran status, physical or mental disability, and genetic information. The general rule of thumb is you don't want to ask anything that could reveal a protected characteristic that you're not allowed to take into consideration when making a hiring decision. You shouldn't be trying to solicit that information or use it in making your decision. In order to get at the more subjective qualities and characteristics needed for a job, you can use performance measuring questions. For example, explain how this particular job is one in which an employee will need to complete several tasks all at once, and you have to be flexible and know how to prioritize. You can ask the candidate how they would do that and how they've demonstrated flexibility and an ability to prioritize in the past. So now that we know the protected categories, we will turn to what questions can you and can you not ask in the hiring process. So here we're looking at a list of topics to be aware of during the interview and hiring process. So we'll go through some do's and don'ts of questions you can and can't ask during interviews. So first, education. You can ask questions regarding a candidate's education and training to the extent that there's a business reason and it relates to your reason for asking for it. However, an employer really should not require a higher level of education for a certain specific job than necessary. When it comes to marital family status and pregnancy, don't ask questions regarding those during the interviews. No questions about marital status, pregnancy, future childbearing and children, whether they have kids or planning for kids, what their child care plan is. You really want to steer clear of those topics during interviews and not solicit answers based on those. Disability. You cannot ask if a person has a disability or for that diagnosis. You can't ask about previous workers' compensation claims. You can inquire whether an applicant can perform the essentials of a job with or without accommodations. And we're going to discuss accommodations in a little further detail later on. And you can inquire whether an applicant can meet the requirements of the employer's work hours, overtime hours, and attendance policies. Age, you can't ask about someone's age unless you're asking if they're under 18 or over 18. For that reason, you also want to be careful about soliciting age-related information, such as dates of schools or asking when the applicant graduated. In terms of national origin, you can ask an individual if they're legally authorized to work in the US, but you can't ask questions about where an applicant was born, where an applicant's parents were born. Salary, that's a very Massachusetts specific topic. In Massachusetts, employers cannot screen job candidates based on their past wages, and you can't ask an applicant for their salary history prior to extending an offer of employment. Sometimes when an employee raises their past salary history in an interview, an employer can to some extent verify or confirm that what the employee said in the interview is true, but really you want to steer clear from salary to the extent possible in the interview. You can talk about expectations in terms of what you intend to pay someone in terms of salary and see if that's something that they're interested in, but not ask them about their past history. Criminal records. There are various laws which generally limit your ability to make pre-offer criminal background checks. Sometimes first you need to extend an offer and then employment be contingent on an employee passing a background check. But you're very limited in terms of criminal records about asking about certain types of convictions depending on how long ago they occurred, the seriousness of the crime, and whether or not that crime was actually relevant to the job, and that can change depending on the occupation and what the crime was. And also considering past arrest records, you can't consider those, though consideration of pending arrests and pending crimes is sometimes permissible. Religion, it's okay to ask if someone's available on weekends or to work certain schedules if that's relevant and necessary for the job. However, you don't want to ask questions about religion. Similarly, with military status, it's okay to ask if someone's a veteran and what branch they served in, but you really have to be careful about asking any further questions from there. Don't get into type of discharge or anything like that. And similarly with genetic information, sexual orientation, not things you should be trying to solicit from someone during an interview. Does anyone have any questions about that yet?
Yes, Daniel, we have quite a few. So if you if we could go back to that slide just a moment ago, that would be lovely. Thank you.
Sure.
And everyone, I love these questions. Thank you for including them in the chat. Again, if you want to ask your question anonymously, feel free to do that. So you don't have to be identified with your name if that's an option you have. So one of the questions that I see here is on the protected categories. Does that apply for both hiring employees and independent contractors, or only one of those?
Well, so technically it can be both. We're talking here mostly about employment, and to the extent 151B, the Massachusetts law, which applies to discrimination in employment, but even third parties, independent contractors, volunteers can be protected under discrimination laws, not in the employment context. So it can apply more broadly. And really, you just want to avoid, you can easily be held accountable for third-party discrimination. If an independent contractor is causing a situation for one of your employees, that's something you can be held accountable for too. So really, they can apply more broadly. It depends on which law you're looking at specifically.
Great. And one on salary. You know, I think Massachusetts is actually a leader in this area of putting laws out, preventing people from asking what your salary history was. Number one, that's what we've heard is that's a way to maintain discrimination from one position, particularly for women and people of color as they move along their careers. Someone asks here, can you ask someone what salary range they are looking for?
Generally, you can solicit that sort of information. The law focuses mostly on past wages because you're trying to avoid just the pay equity gap. The same way you can advertise a salary range for the position, you really want to be careful when you're talking about salary in general, and it's better for the employer upfront to be making its decision based on what the position is and what you're looking for. So if you start with a range that keeps you out of trouble a little more easily than soliciting it from the candidates, and then based on what the candidates are saying, maybe you're even unintentionally making a decision based on past salary history.
Okay, and another one is on gender pronouns. So someone asks, best practice for inclusivity to ask people their pronouns, but does that pry into their gender expression? For example, when this person recently interviewed, they said, "Hi, my name is blank, and my pronouns are blank." I didn't explicitly ask them their pronouns, but it was implied.
Understood, yes, and it can definitely be complicated. And for an example, we'll cover a few examples that sort of hit on what happens when the candidate is bringing up this information and you're trying to ask these narrowly tailored questions, and then you're still getting that information. You can't stop a prospective applicant from raising certain issues, right? But to the extent possible, you want to make sure your focus, both because it should be as a business on getting the right candidate for the job, you want to make sure your focus is on what the job needs, and that you're not going down a path where suddenly you're talking about an employee being a member of different protected categories and how that might shape whether or not you think they're the best candidate. That's what you don't want to do in hiring.
Okay, and just a reminder for folks, if you can use the Q&A function on Zoom and not the chat, that would be great, because it's an easy way for us to organize all the questions. We are getting a lot of questions, which is wonderful. Someone asks, what do you need for employee documentation? Maybe you'll get to this later, but I'll pose it to you now.
Yes, that's a spoiler, because that is still to come. Documentation is incredibly important, and I promise to go through that in a lot of detail. And if you still have questions, happy to answer those as they come up.
Okay, I think we can go on.
Great, thanks. So as promised, we'll turn to an example of some issues that can come up during hiring. And Luke, if you're willing to role play with me again, that would be great. So in this example, you're interviewing Mel for a weekend position. Mel mentions in conversation during the interview that he is active in his church. What can or should you ask him? So we'll do another role play here. The setting is about 3/4 of the way through the interview. I'll be the interviewer, and Luke, if you could be Mel, that would be great. So Mel, how was your weekend?
Oh, it was great. I was at my church both on and off on Saturday and Sunday. There's a lot going on this season.
Oh, really? Where's your church?
It's about an hour away from home.
Oh, wow. So how can you possibly work on the weekends then with all of that religious stuff? End scene. That's a good example of what you don't want to do. That was not an applicant intentionally baiting me, but I hear that Mel's spending a lot of time at his church, and I fell into that trap of asking him more about that and trying to imply in my question that because of his religious involvement, he might not be a candidate for the job. Really what I should ask is, and should tell him, are the hours of this position are Saturday and Sunday from 7 to 2. Can you work those hours? You really don't want to follow Mel down that road, and you want to reshift the focus in the interview on the job qualifications you need and not the information you don't. And so now we'll turn to another example. So in this example, you're interviewing Heidi for a job as a receptionist. Good attendance is a must. During the interview, Heidi mentioned she's 5 months pregnant. What questions can you ask Heidi about her pregnancy, maternity leave, and or her intentions after the baby arrives? And this one will set the scene as halfway through the interview. Luke, you can be the interviewer. I'll play Heidi.
Cool. So when are you available to start?
Right away. I'm 5 months pregnant, as you can probably tell, but I'm ready to begin.
Oh, wow. No, I didn't realize you were pregnant, or at least not that pregnant.
Yeah, I am, but don't worry, it won't cause any problems.
Really? Are you sure you're going to be able to be here on time?
Yes, of course.
Well, what about daycare and your schedule after? Do you have that arranged?
I don't really feel like I have to tell you all of that, at least not yet.
Yes, you do. I've dealt with new mothers before.
End scene. So what should Luke have said there? He, again, should have tried to focus on what he needs from an ideal job candidate. For example, telling Heidi that he needs her to start at 8 a.m. 5 days a week and that reliable attendance is key, asking her if she can do that. He doesn't want to, he doesn't want to leave Heidi with the impression that his hiring decision is going to be made based on Heidi's pregnancy. That's what you want to avoid. So if anyone has any questions on any of those examples, we can talk more about that. Otherwise, we'll turn to wage and hour issues.
I think I would just ask this one question to you, Danielle. So what if you're dealing with, what if these conversation pieces come up and it's like, it's not from a place of I'm trying to investigate and trying to, find reasons to, eliminate a candidate from a position. What if it's like, in the previous example with Mel, it's like, oh, you go to that. Oh, I go to that church too. Do you know, Doris or whatever? Or, if it's, the interviewer is also a parent and it's like, oh yeah, I remember my pregnancy. It was like, and it's not in the context of talking about, work. It's just like, conversation, trying to humanize the people, humanize yourself as an interviewer and, the candidates you're asking. Because I imagine that comes up in a lot of contexts.
It does. And it's hard because, people spend a lot of time at work. You hear a lot of talk about, we're trying to strive for this kind of culture and this is what we want the field to be in this workplace. But really, what it comes down to legally is potentially needing to be able to justify your business decisions. And you really don't want, whether or not someone goes to the same church as you, so therefore they share your religion, and now you're closer to hiring that candidate versus a candidate of a different religion or with whom you did not discuss religion in the interviews, which again, I would point to avoiding that. But so you really want interviews to be focused on the job and what the job needs to achieve, and avoid going into these protected categories, because at that same time, while that conversation could seem harmless, by going down that road, discussing that person's religion with them, then if they don't get the job, it might feel to them, and they might raise a claim that the decision that caused them not to be the employee that you hired was based on that conversation. And just the fact that you went down that road makes it a lot more difficult from a risk standpoint to justify going forward. So that's some of the risks and how they can come up. So now we'll turn to talking about wage and hour issues. Now this is also a huge topic, but generally wage and hour laws address how, when, and how much employees are paid and should be paid. These claims can definitely be on the rise, especially in Massachusetts. Massachusetts, once again, is a very employee-friendly state. So it's very important to be clear with employees regarding the compensation and benefits that you're promising them. Some key tips and best practices for Massachusetts employers. Number one, know your legal obligations. That includes your obligations regarding when and how to pay employees for their work, calculating the hours that they worked, meal breaks, and overtime. In addition, you want to make sure you're maintaining clear policies and practices relating to employees punching in and out so you can calculate the hours they're working, breaks, and approving overtime. It's important to regularly review your exempt and non-exempt classifications for compliance. And exempt and non-exempt has to do with overtime and employees who are entitled to overtime. You also want to conduct routine audits to ensure that you are complying with all of the laws regarding wage and hour claims. It simply comes down to paying employees correctly for their work under the law. Now there are multiple laws that can dictate how that's done. But in essence, as we discussed before, the law requires that if an employer suffers or permits an employee to work, an employee needs to be paid for that work. And trouble tends to come when that doesn't happen. Particularly in Massachusetts, liability for violating some of these wage and hour laws is very ominous because it can come with mandatory treble damages if there's a violation found. Treble damages means 3 times the amount that would be owed. So for instance, if you failed to pay an employee $1,000 in Massachusetts, once that claim is filed in court, they could get treble damages, meaning $3,000 in addition to costs, interest, and attorney's fees. So you can end up owing an employee a lot more down the line if you mess up their payment now. So to ensure that you and your employees are on the same page, you can consider setting out the terms and conditions of their employment in an offer letter. by clarifying what their title or position is, their start date, any terms relating to their employment, such as the rate and frequency of their pay, how they're going to be paid, their hours, and if there's any benefits that they're eligible for. Another pro tip is offer letters, keep including that at-will employment language. We discussed at-will employment, and it's just very important to emphasize that you're not entering into a contract with the employee if that's not your intention. If you still want to be able to terminate an employee for sort of any reason or no reason at all, so long as it's not an illegal reason. So I'll just touch on few of the basics of wage and hour laws, because that's another topic we could probably spend all day on. There are laws that concern the timing of pay. So most employees have to be paid their wages within 6 days of the end of a pay period in Massachusetts. When an employee is terminated or laid off, they have to be paid in full on the date of their termination. If an employee resigns, then they have to be paid in full on the next regular payday. Even if you, and this goes back to the employee independent contractor issue we were discussing before, even if you try to agree to some other payment method with the employee, that doesn't necessarily get you around these rules. The wage and hour laws in Massachusetts have provisions specifically stating that you can't waive them by agreeing to something else, the same way you can't determine whether or not someone's an independent contractor just because they signed an agreement saying that they are. The Massachusetts Wage Act is the law that covers the payment of wages in Massachusetts. That can include vacation time that you've set out as wages, and that has to be paid to an employee upon termination if they have any accrued but unused vacation left at the time of their termination. Similarly, the law defines commissions and when they have to be paid out even upon termination. There are rules regarding meal breaks. For instance, an employee is entitled to a 30-minute unpaid meal break for every 6 hours that they work. Minimum wage laws, overtime laws. Overtime, we had said that basically that's any time an employee works more than 40 hours in a work week, the employee is presumed eligible for overtime. There are some exemptions and essentially exceptions from the overtime rule, but if the employee is subject to overtime, then they're required to be paid time and a half, so 1.5 times their regular rate of pay for all hours that they work over 40 hours a week. Any questions on wage and hour laws?
None quite yet.
Okay, great. Well, we'll turn to a quick example of wage and hour laws at work. So in this situation, one of your servers, Alex, takes a 30-minute unpaid lunch break each day. The last few days, you've noticed him munching on his gluten-free, carb-free, taste-free tofu salad in the kitchen during his break. But you've also noted that he sometimes assists other servers or a customer here and there during his break. Does any of this trouble you? So we can run through a little role play to set out how this goes. So after the 3rd day of observing Alex take his lunch break in the kitchen, is the setting for this scene. I'll play the manager. Luke, if you'll play Alex. Hey, Alex, I noticed you've been eating your lunch at the counter in the kitchen.
Yeah, I love the warmth of the place. It really grounds me, you know?
But I really want to make sure you're getting a true break.
It's no problem. That's my break. I'm cool with it. You know, I love to help others. I don't mind doing odd jobs while I'm eating my lunch. It's all good.
Oh, okay. Well, I guess if you're okay with it, then that's fine. Just don't complain later that you didn't get paid, okay? So, end scene. That's not how a manager wants to handle that situation. Instead, a manager should say something along the lines of, you really need to not be working during your break and you can't take your break in the kitchen. That's what our break room is for. If you have rules about where the breaks should happen and should not happen. Basically, this is just another example of how you can't get around the wage and hour laws. So if you're giving someone a half-hour unpaid break during the day, you need to make sure that they're getting that break and not doing work during that time. If they're doing work during that time, then they need to be paid for it because they need to be paid for their work.
And we do have a wage and hour question, Danielle.
Oh, okay, great.
So if you're a non-exempt employee and are there protections for working more than 40 hours a week?
So if you're a non-exempt employee, so in context of overtime, you're exempt from overtime means the overtime rules don't apply to you. If you're non-exempt, that means overtime rules do apply to you. So if you're working over 40 hours a week and overtime applies to you, then you need to be paid overtime. If you're asking whether or not there's protections for people who aren't subject to overtime based on their hours worked, it can depend. There's a lot that gets factored into whether or not someone is exempt. Massachusetts has its own rules, and federal law also has rules depending on whether or not somebody can be an exception from overtime. So you would need to prove that they fall outside of the overtime rules. Does that make sense? Okay. So turning now to another key issue that can face employers, reasonable accommodations. This issue comes up in the context of employees who require an accommodation based upon a physical or mental disability, but also employees who need accommodations based upon their religion. As we've discussed, the law prevents discrimination against employees both because of their physical or mental disability and as well because of their religion. A need for accommodation can come up during the hiring process. So it's really important that employers are attuned to this right from the beginning of bringing on an employee. Employers do have a duty to reasonably accommodate even during the application and interview process. So make sure your hiring team is aware of these issues. What's involved in determining if the duty is triggered to accommodate someone and who qualifies, that's what we're gonna look at specifically. In the disability context and in the religious accommodation context, a manager really needs to be able to spot a request for reasonable accommodation. It's an employee's job to put the employer on notice of their potential need for an accommodation, but beware that there really aren't any magic words. An employee doesn't need to say, hey, employer, I need an accommodation. In fact, many employees might not know the different laws that they're subject to and how to raise that using sort of specific language. So employers really need to be on the lookout if they learn any information that could trigger their duty that they're engaging in this reasonable accommodation process. So what happens once an employer finds out that there might be a potential need for an accommodation for an employee, you engage in what's called an interactive dialogue. So that's really a conversation between the employee and employer where you want to find out not sort of the underlying basis. You don't need to understand what an employee's disability is. All you need to understand as the employer is what are the employee's restrictions and how does it limit that employee's ability to do the job. So sometimes an employer might provide a job description or seek information from an employee's doctor to try and figure out, is there a way where the employee can do their job with an accommodation but still get the job done? That's really the goal of this interactive dialogue. And especially, it can be difficult because a key term here is these are reasonable accommodations. Just because an employee asks for a certain accommodation does not mean that that's the accommodation you have to give. It all turns on whether or not something's reasonable. And an employer doesn't have to give an accommodation that would cause them an undue hardship. That's sort of the legal terminology around it. Basically an undue burden on the employer that makes it too difficult to provide an accommodation that could work. Now, the larger a business, the harder it can be to show that providing one employee this accommodation is going to cause an undue hardship. It's really important for employers to never outright reject requests for accommodation. There always needs to be a back and forth conversation with the employee. Even if an employee asks for some pie in the sky accommodation that you know when you go talk to HR and your counsel that is going to get shot down, you still need to invite the employee to talk about different accommodations that could work. You need to analyze the suggestions the employee makes to you, and then you can also offer back other creative options that could work. You don't have to provide an accommodation if it causes an undue burden, but it can be difficult to prove that something is an undue burden. And you don't necessarily have to provide the employee the accommodation that they ask for. So reasonable accommodations, for instance, can include things like making existing facilities more readily accessible to a person with a physical disability, restructuring of a job or modifying work schedule or hours. Sometimes reassigning someone from one position to a different open position might be an accommodation which is reasonable. It's again a very fact-specific inquiry in terms of what might be reasonable, but the key is to engage in that interactive dialogue and keep discussing it with the employee. There are certain things that are unreasonable accommodations that, at least as far as courts have determined. That can be something like indefinite leave, an employee who says, I need to go out of work essentially forever. I have no idea when I'm going to return. That could, in some circumstances, be unreasonable, but again, it can be very fact specific, and the employer needs to show that they've tried to engage in that interactive process. If an employee is just asking for a little more leave time, then they still might be asking for a reasonable accommodation. This is something that might be easier to run through a specific example. So let's try this. So Celia, your bookkeeper, has been struggling to keep up with her work lately. You've also noticed that she's been late to work with some frequency in the last few weeks. When you sit down to talk to her about it, she indicates that she's trying her best, but that she's just been having a hard time of it due to her chronic depression. What do you say in response? So what if I said something along the lines of, well, Celia, if you can't do it, you can't do it. Do you think you should resign? Well, that's not a particularly helpful approach for an employer to take. At this point, Celia has flagged a potential disability issue for you, and you need to engage in that interactive dialogue with her about her potential accommodations and her needs going forward. It's much better for an employer to respond with something like, thanks for letting me know. I'm going to give you some paperwork that you can give to your doctor. We'll obtain some more information about any restrictions you have due to your depression, and then we'll take it from there. You just really want to ensure that you're talking through the reasonable accommodation process is huge. So that's just really important and good to do. And do we have any questions about accommodations?
I do not have any questions on that.
Okay. Now we can turn to time away from work. So it's really important for employers to know all the laws that apply to your business that require employers to give job protected time away from work. Now I've listed a variety of laws here. Massachusetts has several leave laws. Most recently, the Massachusetts Paid Family and Medical Leave Act that went into effect at the beginning of this year. If you don't know about it, make sure you find out about it because it's important, and it's probably the most expansive paid family and medical leave law in the country. And it will quickly be replacing a lot of needs for leave under other laws, or probably running concurrently with them is a better way to state it. But it's an opportunity for employees to get paid leave. The Family and Medical Leave Act that's federal provides for unpaid leave, but the Massachusetts law is allowing a mechanism for employees to access paid family leave. So it's a very, very big issue, very new law, very exciting. We're all still figuring out how it's working because it just went into effect at the beginning of this year. But if you don't know about it, make sure you find out about it. A good way to communicate these laws and leave opportunities to employees can be through an employee handbook, which we're going to discuss a little later. Make sure, though, that you're reviewing your employee handbook regularly and that your business has policies that are consistent with these laws as they apply to you. That can vary depending on what states you operate in. So that's something good to be aware of. There's several different types of leave. We could probably spend a whole day on that. So I'm just flagging some of these for you. These are some of the bigger ones that come up in the Massachusetts context. And so we'll go through just a quick leave example that uses one of the laws. So here we have Donald, who recently started working for your business. He calls right before his shift to say he's going to be late because one of his daughters is sick and needs to go to the doctor. You tell him he'll receive a warning in his file for being tardy, and you require a doctor's note. Did you do the right thing? So in this context, what we're talking about is the Massachusetts Earned Sick Time Law. Under the Massachusetts Earned Sick Time Law, which applies to all employees, full or part-time employees. Whether or not the sick time under the law has to be paid depends on the size of the business. But under the mass sick time law, the company can require documentation for an employee's use of sick time, but only in certain circumstances. From what we know in this example, we have no history of Donald having used sick time more recently or having other occurrences of undocumented absences. So the law in this case seems like it wouldn't apply in terms of a reason for you to justifiably get documentation from Donald. Here, he's told you enough that you're aware he's using sick time for one of his family members. And under the Massachusetts Earned Sick Time law, that is a permissible reason to use sick time. So you just want to make sure you're making it available to Donald under the laws that apply to your business. Any questions?
No.
No? Okay. Always feel free to submit questions. But
now we just got one.
Sorry, go ahead.
Yeah. If you see an illegal or outdated policy being enforced in your workplace, who should you contact?
So if you're seeing a policy in your workplace that seems outdated, just seems wrong, I mean, first, if you're within your organization, talk to your HR. HR is usually very up to date on policies, which is great, huge resource. And then also your counsel. So we'll actually cover this with employee handbooks, but usually I would recommend businesses have their employee handbooks reviewed about once a year, just to make sure that they're staying up to date with all of the changes in the law. Unfortunately, they can change quite frequently. For instance, if you had your handbook updated 2 years ago, well, now we have the Massachusetts Paid Family and Medical Leave Act that you would probably want to notify your employees of how that policy applies and have a policy in place so employees know how they can use it, thus making your life easier later on when there's a clear process for how that works. So that was a perfect segue to employee handbooks. Employers want to think strategically about employee handbook. Everything has pros and cons, and if you're not careful with your handbook, it can create legal exposure by an employee being able to rely upon it as a contract and then holding the business accountable for all of the policies in the handbook. You don't want your handbook to include any policies that your business is not going to follow. Handbooks are not for wishful thinking. They're really the policies that you need to have in place and follow for your employees. You want your handbook for your organization to be personal to your business. That means that sometimes pulling policies from online and just throwing them in the handbook without modifying them to your business really doesn't do you any favors. You might have pulled something that has a process that your business would never use, but now you have an employee complaining that you didn't follow the process and you might be facing some liability for that. Handbooks are different than operation manuals and vision statements. The handbooks don't exist just for HR to know how they handle a FMLA request, for instance. That can be more of a step-by-step guide for how you want managers or HR to handle something. This is really the place where employees should go for all the important policies that relate to them and their employment with your business. So under Massachusetts law, handbooks can be deemed an employment contract. And so the difficult position that can put employers in is that you can't have it both ways. You can't expect employees to follow all of the policies in the handbook and then think that you're free to ignore those policies yourself. And just a small, disclaimer in fine print where you say, oh, it's not a contract, that might not be enough to really make sure that it's not a contract. You need to have very robust at-will employment language. So that's something to keep in mind as well. In addition, if you have a standard progressive discipline policy, and that means the process of escalating discipline to someone through to termination, whether it's verbal warning, written warning, suspension, just an elevating and escalating level of discipline, you want to make sure that whatever you have in place is something you're actually using and that you're not tied to using that. For instance, if somebody does something egregious, but they have no sort of history of any other employment issues at your business, you still might want to be able to use that at-will employment doctrine and maybe escalate the situation to termination if it's warranted based on the employee's conduct in that one instance. But if you have a policy that says you need to have a verbal warning and a written warning and a second written warning and then a suspension before you can terminate someone, you're making it a lot harder for your business to react to those situations. So in order to try and cut against your handbook being interpreted as a contract, you want to include express statements in the introduction and then throughout the handbook that it's not intended to be a contract. You want those disclaimers to be frequent and prominent so an employee is very aware of them. You want to include an employer's ability to their right to unilaterally modify the handbook. You don't want to need employees' permission to change your policies. It's very natural and normal for employers to regularly update their policies based on how things progress and what might be best for the business. You'll also, based on the progressive discipline issue that I just raised, want to include a disclaimer stating an employer's not promising any particular disciplinary process or progress of discipline prior to termination. Again, you just don't want to overpromise on something you're not going to deliver. And again, just be prepared to follow all of the rules that you put in an employee handbook. So now we'll go over some policies you want in your handbook. Basically, these policies need to be in writing somewhere under the law if they're applicable to your business, because some of it depends on business size. But if you need these policies in writing, why not have them compiled in a nice, easy handbook that all employees can look at rather than having to sort of fish through different policies on a company intranet or something that way. A key, again, is to make sure that the list of protected classes that you list in your handbook is up to date based on the state you're in. Massachusetts, as we mentioned earlier, has a longer list of protected classes, and you want to make sure you're setting out your anti-harassment, anti-discrimination policies to include all of those protected categories as well. So here I've included what is a sample table of contents for a handbook. Some businesses might not need all of these policies. Again, everything you have in your handbook, you want to make sure you need it and you're following it. If it's something that doesn't apply to your business, don't include it in the handbook, again with the caveat, except if it's legally required. If you need to have a discrimination policy, then make sure you have it and it is applicable to your business, even if you think it might not be. So the sample just goes through a lot of different things. I don't want to spend too much time on it here, but if anyone has any questions, let me know. A key thing I will point to is the last bullet point on the right, the acknowledgement. That usually it's a 1 to 2 page document at the end of a handbook where you're saying you've read the policies, you understand them, you know that your employment requires you to follow those policies, but also use that as an opportunity to really spell out that the employment of that individual is at will and that you're still not creating a contract even though you're having them sign an acknowledgement. And again, we talked about how you really want to try and be updating your business's employee handbook on a yearly basis, and it'll give you a chance to keep going back and reassessing what policies do you use and what policies don't you use and make updates based on that. Any questions?
I have a question, Danielle. If you could just go back one slide. It was a little selfish question from me. A lot of our folks are maybe an office of 1 or 2 and balancing 1,000 jobs into, this is a big list. It's very extensive. Yes. Is there any resources or a head start or folks people can work with in order to start to think about where they pull all of this material together for them? We don't keep samples of employee handbooks on file at the council, for example, so we don't have that kind of library that we can share as a template or something. But for folks looking to go down this road of building out a handbook, where could they go? Yeah, so there are, and I will caveat this, but
There are lots of online resources. If you type in one of these policies, you'll come up with a sample policy. But what you'll really need to do, rather than just, it can be very easy to cut, paste, and all of a sudden, look, you have a handbook that's 200 pages long. You have no idea what any of the policies say, and your business, all your managers and HRs aren't trained to implement that policy. Don't do that. That can be very risky because you might be subjecting yourself to rules that you don't even fully understand. And what can be hard with typical online samples is you might not know what state they're crafting that for. And if you don't understand the law behind why they're in there, then you might be signing yourself up for obligations that you just don't have in your state. So while I'd say it can be a good starting point, attorneys in employment law do this a lot. I mean, your HR people probably have some policies. Sometimes it can be helpful as a starting point, but you really need to break down how your business looks at it and how they're going to deal with it and understand which things are optional versus which are required. For instance, in Massachusetts, your business, if you have 6 or more employees, you need to have a written anti-discrimination, anti-harassment policy. You need to make sure you have that in place. Mm-hmm. Very important. Luckily in Massachusetts, though, we have the Massachusetts Commission Against Discrimination. That's the state agency that investigates employment discrimination retaliation complaints. They have a sample model policy on their agency's website. And when a state agency who does the investigation of those complaints gives you a model policy, you love that policy because this is great. This is exactly what they think employers should have in place. But now how do you tailor it to your business, or who should the contact be in business for reporting those complaints? That's when you want to talk to HR. You want HR to talk to your outside counsel so you can make sure you're still tailoring it within the confines of that model policy.
Yeah. And someone put in the comments, I think it's just to the panelists, but they mentioned that payroll services also usually offer a handbook service for a fee. Your mileage may vary with your company, but they'll at least be familiar with regulations. And also, this is something that we provide referrals to our volunteer attorneys all the time. We work with a number of management side law firms, much like Morgan, Brown, and Joy, where Danielle is, who will help and review and help you craft and evaluate your employment handbooks as well. So that's something where I would, selfishly plug ourselves, the Volunteer Lawyers for the Arts. And I'll put that information in the chat too.
Great, thank you. One last question that came in on the handbook.
Sure.
When the handbook is updated, would the newest version automatically be considered the contract?
So it will depend on what sort of language you put in there. And again, you want to be putting in all the different language that helps cut against it being interpreted as a contract to increase your protection from risk. But you also want to be tailoring your policies in such a way that if it is held as a contract, you're not that scared of it because you've really gone through the policies and made sure that what's in there is what you're doing. So I'd say it can depend. And it'll also depend on what language you have in there about the unilateral right of you as a business to update your policy. And are you sharing that information with employees? For instance, if you just keep your updated employee handbook on your company intranet website, but you're not sending out any notice to employees that it's been updated, it's a lot harder for the employees to even know or seek out that policy. You might want to require, an updated acknowledgement every time you update the policy, and that at least helps you show that the employee was aware that it was changing.
Great, thank you. I think we're good.
Great, wonderful. Okay. So turning to handling harassment and discrimination complaints. We've touched on this a little bit with the employee handbook, but you want to make sure your business has these policies in place. You want to know how it's defining discrimination and harassment, if it's covering all of the protected categories. You want to make sure your employees know who to go to with an issue. I can't tell you the number of times that you find out later that an employee who's no longer working for you made complaints, but they just didn't ever make its way to the right place. They didn't make it to HR, they didn't make it to their manager, and that can still result in liability for the business. So the clearer you make your policy, it really benefits you and it benefits the employees because you're funneling them to the right place. So you really want to identify the people in your business who know how to handle and respond to discrimination and harassment complaints, and make sure they either know how to investigate those complaints or they know how to take it the next step. And now that the complaint has been made to them, they go where they need to go so that an investigation is completed. Regular training on this is recommended, not just for HR and the managers, but also for employees. Again, the more employees know, one, that their company is taking discrimination and harassment complaints seriously, and two, how to report an issue, the better for the employee and the better for your business. So it's a very important issue, and it's critical that you make sure it is handled correctly. So we can turn to another example. So you sit down with Henry to deliver his performance review. When you announce that his overall rating is a really needs to improve and fast, he's crying. That's when he informs you that he believes his supervisor is unfair and that he doesn't think she likes older employees. What do you do now? So we'll run through a role play, pretend that we're at the end of the performance review meeting between Henry and the general manager. I'll play the general manager. Luke, if you'll play Henry.
Mm-hmm. I'm a lawyer, so I have trouble projecting emotion, but I'll do my best. So I've felt my supervisor is unfair for a while now, and this proves it. She has a problem with anyone older than her.
Don't be ridiculous, Henry. You're just saying this because you're unhappy with your review.
That's not true. That's not true.
Are you saying I should change the review? Now you're accusing your supervisor of being a liar? Just take some responsibility for your poor performance. End scene. So my response as the manager in that situation was just not very productive. Henry, right or wrong, is raising a concern that his supervisor is treating him differently based on his age. Instead, as the manager in that situation, whether you agree with the person or not, try to take your emotions out of it. Now that is very hard, as Luke said, not always for lawyers, but it can be very hard when it's your business and for the managers. That's why training is so important. But it's much more productive for the manager to respond and let that employee know that your business takes those complaints very seriously and that you will be in touch with them to follow up. And now that manager is either tasked with looking into it or tasked with taking the complaint to someone who will look into it. Here, communication is key, and you really want to make sure that your employees feel you're taking it seriously, and you should be. Now we'll turn to retaliation. This can often go hand in hand with discrimination. Retaliation is, simply put, it's the act of revenge. For example, an employee complains about discrimination, so you fire them. That's illegal. To set forth a claim of discrimination, what an employee has to show is that they engaged in some form of protected activity. That means they did something protected by law. That can be complaining of discrimination, for example. Then they need to show that there was an adverse employment action. The most simple action is termination. When the employee is fired, that's clearly a negative employment action. But it can also be a demotion or a transfer to a position where they don't have the same pay or benefits. And then thirdly, the employee needs to show a causal connection, which connects their protected activity with the adverse employment action. And that's the employee complained about the discrimination, you fired them, and the reason you fired them is because they complained about the discrimination. So most employment laws contain some sort of anti-retaliation provision. That means the anti-harassment and discrimination laws, as well as if employees are complaining about their wages, there are also anti-retaliation provisions. If an employee says to you, hey, you need to pay me, you forgot to pay me for my last month's wages, and then you fire them, they too could bring a retaliation claim. You want to make sure in your employment handbook that your policies include strong no retaliation provisions to ensure that as a business, you're being very clear that is not the goal, to retaliate against an employee who engaged in some sort of protected conduct. A retaliation claim, the difficulty about these in court is those claims can survive even if the underlying claim is without merit. So these can be sometimes the trickiest and most expensive to litigate. So if we go back to the example of an employee complaining about discrimination and then getting terminated, they could bring a discrimination claim because they said they were discriminated against. And they can also bring a retaliation claim because they say because of the discrimination complaint that led to their termination. Even if the employee doesn't prove that underlying claim of discrimination was true, they could still prove their claim that they were retaliated against because they made that complaint in the first place. So it's important to be extremely cautious when making any changes to the termination of an individual's employment after they've engaged in any type of protected activity. So even if there's a legitimate reason for business to move an employee to a different position or a different retail facility, and it just coincides time after they've complained, you just want to be very careful and cautious and aware of how that could look down the line, because if this claim comes up in court, courts and juries are going to very closely examine your reasons for doing so. And that's when I get to one of my favorite words in law: document. Document, document, document. You can't do it enough. What you do with your documentation, though, does matter. And we'll get into what good documentation looks like. But you want to know why you're doing what you're doing that helps protect you later. So for instance, transferring an employee, ensure that you're putting them in a position where they're not being set up to fail, because again, that could give you grounds for a retaliation claim. So it's really important for employers to have a consistent approach to how they evaluate an individual's performance and ensure that the policies in your employment handbook are reflecting reality. Managers are busy, businesses are busy, and it's very easy to sort of sweep these things under the rug, but they're really things that you can't ignore, and you need to shift your thinking on really embracing performance management. It's important for you to know both the business's rights and the rights of your employees in this process of managing their performance. So we're going to go through a list of 5 easy steps that can hopefully help you embrace performance management and not shy away from it as many people want to do. So we encourage regularly doing training on performance management with managers so that they have good tools and know what the best practices are in responding to employees whose performance is suffering. Managers should be careful about taking and making disciplinary decisions after an employee has engaged in protected conduct. Now, you can still discipline an employee if it's necessary, just always be sure that you're treating them consistently with other employees, treating them like everyone else. You want to keep in mind that disciplinary actions you take after an employee has engaged in protected activity could later be under the microscope, so you just want to do it much more slowly and really think it through before you've done it. As we've discussed today, there's lots of laws that protect employees and their time away from work. You want to know what those are and not discipline employees merely because they've engaged in protected activity or protected conduct. So really, it's important for employers not to be scared of disciplining an employee, and you don't need to be scared about doing it just so long as you have a plan. So run through a mental checklist every time before you're going to issue any sort of discipline, whether it's a verbal warning, a written warning, termination. Are there any accommodation issues at play? Have there been any discrimination concerns? You want to go through that mental list so that you're checking yourself on your decision-making and making sure you're not making decisions based on protected conduct, and that your discipline is fair and consistent with how your business would typically handle that situation. So here are these 5 easy steps. You want to keep in mind, given potential exposure, what can we do to minimize liability in a performance management context? So these steps can help you walk through and just think through discipline before you issue it. You want to start by identifying what the problem is and how it's affecting the business. Then identify the potential rights of employees to engage in that conduct. Third, you want to identify your responsibilities for addressing that problem. For instance, does the employee know that they're not performing well? You know, a lot of times employers say, oh, well, of course they know, they should know better. They know what the expectations are, but have those expectations truly been communicated to the employee? And then identify the resources available to you and the employee. Conversation and transparency is always key. The goal of a business should be for its employees to succeed. If there's a way to make that work, then you want to do that. But it's really important to just formulate an action plan. And if an employee's performance is suffering, you want to give an employee feedback on it. You don't ever want to face an employee who's been terminated for poor performance and that employee has never had a conversation about their performance with their manager. So you want to make sure the employee is aware of it. You want to deliver that feedback and you want to document that feedback. You want to engage in giving that timely and follow up with them as a result, whether they're making progress or whether they're continuing to struggle. You always want to follow up either way, whether they've made good or bad progress. So documentation is very important for several reasons. One, as an attorney who sees this come up in court all of the time, if there's documentation made around the same time an employee was having performance issues and then later a claim is raised, documentation provides the best foundation and defense against litigation. Memories fade. It can take a long time from when an employee is terminated to their case end up being heard in court. It used to be 2 or 3 years ever since the pandemic, with jury trials being pushed back, looking at maybe 3 to 5 years between when they get terminated and when they could be a jury. Sometimes it can be even longer than that. So memories can fade because you're dealing with what's going on with your business on an everyday basis. Sometimes the key witnesses might have left your company, which can make things more difficult to prove as well. It's very easy to show a jury that someone knew about their performance issues when you have all of this documentation, you know, saying this week I talked to them about it, and then here's 2 weeks later and here's a month later. When you have that documentation, it's the best way to protect you and your company. You don't want to be caught ready to fire an employee when you have no documentation in the file when you're firing based on their own performance. So it's really worth spending time to promptly complete good documentation. It really minimizes the risks of litigation, drives down costs of settlement, and in fact deters litigation because you have all of this valuable contemporaneous recording of the issues. So now that I've hopefully convinced you to document performance management, we can discuss what good documentation actually looks like. So you want to provide details of what the employee is doing wrong. Make sure what you're writing is accurate. Don't exaggerate it or falsify it. Make sure it's complete. Include a date so that 3 years down the line, you know exactly what day something was issued. Work with the employee and create a plan for them to improve and tell them what those standards are in order for them to improve. Give an employee an opportunity to sign the documentation and see it or object to it if they want to dispute it, but you want the employee to know exactly where they stand. A lot of cases arise because an employee feels like out of the blue they were terminated. On the business side, usually the employer doesn't feel like it was out of the blue. It seems like it was a problem and a consistent problem over time, but if you don't have documentation showing that, you can really face some liability down the line. And lastly, just be professional. Remember, someone else could be reading this down the line. Juries could be reading it. You know, the company CEO could be reading it. So don't write anything embarrassing. Just keep it professional, appropriate to the situation, but accurate. Are there any questions?
Well, we've just got, I mean, we're almost, this is an action-packed presentation there, Danielle.
Yes.
So thank you very much. We're almost at time, and I see 2 questions in. So however you want to wrap up from this point.
Sure. Well, we're just about at the end. Termination is just basically the last step of performance management. Not every performance management issue ends positively. And the same rules with documentation pretty much apply to termination. You want to clearly communicate with the employee. You don't want to make rash decisions. You want to make sure everything's thought through and careful, and you want to document. You want the employee to know exactly why they're being terminated. Don't confuse it with a layoff. They're being terminated for performance. Just really be honest about what it is that the employee did that led to the issues. So now we can turn to questions. We'll just skip the last example.
Great. And we're just going to have time for 2. We've been answering questions throughout this presentation. So thank you, everyone, for hanging in there for 90 minutes. This is a dense presentation. I say that in the best way, totally possible. I think everybody got their money's worth today. So thank you. Just 2 quick questions. One, kind of a broad picture question. If you're the only salaried employee for a nonprofit or a business you run, do all of these laws that you've talked about today still apply regarding leave and overtime and so on?
So it's hard. So leave laws will probably apply to you if you're an employee. It can depend on the law and depending on the size of your employer. The overtime, you might be exempt from overtime if you're salaried, but just because you're salaried, you're not automatically exempt from overtime. You need to fit within one of the exemptions to overtime. For instance, there are exemptions for professionals such as lawyers that are exempt from overtime, or different admins and executives. So it can depend on the specific facts relating to your business.
Great. And the last one for me here, when documenting something, we just talked about documentation. How do you show that it was created contemporaneously? How do you make sure that it's date stamped or somehow has a moment in time?
So in mark it as in time if this is something you're showing to the employee, right? Say it's just a verbal, but you can still document a verbal warning to say that they received it. Give the employee a chance to look at it. It makes it official. Whether your business prefers doing that by email or if they have a set form that they use, email will date stamp it. And if you're reading and signing it, you have a witness who knows it was provided to the employee and the employee is either reading and signing or refusing to sign, you can make a notation of what date that they did it and were presented to it.
Great, thank you. Luke, any other parting words?
No, I mean, I think Danielle covered everything basically. I would just say she will be coming back for our last of our workshops on work from home. So really excited to talk with you again in a couple months, Danielle. And I left my information for how to apply for legal services through our program in the chat. So that is available. And also, you know, Danielle put our contact information here, so you can also reach me directly if you have any questions about anything Danielle talked about and you actually know you want to take a further affirmative step and talk to an employment attorney about any of these issues. You know where to contact us. We're happy to help you.
Great. Well, I just want to close here by saying thank you, Danielle and Luke. This was pretty phenomenal. And thank you for taking your time out to provide such a valuable resource to our field. As you can tell, a lot of folks really responded today. For those of you who attended, this is recorded. We're going to upload this probably tomorrow morning. And you'll get an email from me with this really comprehensive presentation, and also with the recording to share to board members, because I know a lot of board members take this on, as we just don't have human resources. We don't have legal teams on staff. So feel free to share this around. Carmen put in the chat all of our other legal sessions. We're with Luke and Jim pretty much weekly for the next couple weeks here. So depending on what you're looking for, feel free to register for that as well. Otherwise, thank you so much for the two of you, and thank you everybody for attending, and be safe out there, and we'll see you again in another workshop. Thank you.
Great.
Thank you.
Thank you.